This Honorable Court of Tennessee is now in session.
Thank you and welcome everyone to this, the November call of the Tennessee Court of Criminal Appeals docket here in Jackson, Tennessee. The judges on the panel with me today are Judge Easter from Franklin, Tennessee, Judge Ogle from Sevierville, Tennessee. I'm John Everett Williams from Huntington, Tennessee. You have the entire state represented here today with the 3 grand divisions, and each side is given 20 minutes unless we have approved otherwise. I understand that the appellant has already asked for 5 minutes for rebuttal, which we will approve, and I'll try to help keep up with that time. With that being said, is there any other preliminary matters that we need to address?
No, sir.
Seeing none, Madam Clerk, call the first case.
State of Tennessee versus Tarrance Perry.
And I'm sorry, this is the second case. Please proceed.
Morning, Your Honors, and may it please the court. Kendall Stivers Jones from the Appellate Division of the Public Defenders Conference on behalf of the appellant today, Mr. Tarrance Perry. In this case, Mr. Perry was indicted on and convicted of 1 count of rape by force or coercion. However, the state's proof at trial, especially during the direct examination of the victim, focused significantly on whether or not the victim consented to the sexual penetration. And lack of consent, as this court knows, is a separate mode of culpability for rape, a different element. The closing argument also focused on the lack of consent as well, going so far as to define the use of force or coercion as a lack of consent, which conflated 2 separate elements of the offense of rape and modes of culpability for the jury. The jury was instructed only on rape by force or coercion and not by lack of consent. And the issue in this case is there was a variance. The issue in this case is whether that variance was harmless if the jury had sufficient proof of the other mode of culpability, lack of force or coercion, such that it would expose Mr. Perry to prosecution for this same offense a second time. The state here argued and presented proof of another mode of culpability for rape that was not set forth in the indictment, and that Mr. Perry did not agree to after jeopardy had attached, and there was no amendment. For that reason, we argue that the variance was not harmless in this case, particularly because the state argued during closing, when the jury did not have the benefit of having the court having to read the jury instructions to them, defining all of the elements and what they were required to consider in order to determine Mr. Perry's guilt, until after the state had already made its closing. And the state argued that lack of consent was proof of the use of force or coercion. And I quote, rape is a terrible crime, a terrible charge, but a fairly simple charge, in that rape is the unlawful sexual penetration of a person to another person by force or coercion, which basically means without their will, without their consent. You just can't sexually penetrate someone unless they consent to it. Now, we do not argue that there was not sufficient proof to support a conviction for lack of consent. That was apparent from the testimony of the victim in this case. What we do argue is that the proof, taking the testimony as true, is not enough to support a rape by force or coercion. Yes, Judge.
Excuse me. Can a 13-year-old consent?
A 13-year-old can assent, I think, would be the correct terminology, but whether or not there was consent or assent would mean the difference between an aggravated statutory rape and a rape here. So for that purpose, it is relevant to this case, but no, technically a minor is not competent to consent.
Okay, so would it have been any different if the judge just instructed them that this young lady was too young to give consent, and you should never agree that she did? Well,
that's not one of the elements in rape. It's one of the elements of aggravated statutory rape. But
the lack of consent is not an element of rape, is it?
The lack of consent is an element of rape. The fact that she was not able is not competent because she's 13 years old in this case is not an element or is not a consideration for rape. It's whether or not there was consent at all.
So
Because
you're saying as this gentleman was charged, a lack of consent was an element of rape?
As he was indicted, force or coercion was an element of rape. He was not indicted on consent. Now, in the general statute, and it is possible that lack of consent is an element that may be used to establish rape. But whether or not she consented or assented, if that was not a factor in this case, then there would be no difference between rape and statutory rape, or aggravated statutory rape in this case, because he was more than 10 years old.
Okay.
And we're not arguing that there was no consent in this case. That's abundantly clear from the victim's testimony. What we are arguing is that even if they were charged, or there was an expansion of the proof beyond what was in the indictment, it is harmless if there was sufficient proof of force or coercion. And we argue in this case that it was not, because there was simply not enough to establish that there was use of force or coercion. Coercion would mean that there was testimony that Mr. Perry indicated that he would either hurt himself or the victim if she told anyone, but there's not enough in the record to indicate that that threat was used to accomplish the act of penetration. The trial court did define coercion for the jury, so that's not an issue in this case. Yes, Judge Ogle.
Are you saying that the force or coercion would have to be from the defendant? In the sense, I was looking at what she testified to. She testified, she told him to stop, and then she tried to push him away, and he didn't stop, and he raped her. Now, could that not be, this push away infer that that was some type of force?
That could be. What the case law indicates is that the physical force has to be used by the aggressor, by the defendant, in this case, Mr. Perry. So the question for that would be whether or not his body weight, since there's not testimony that he really used anything other than him being on top of her and she was not able to push him off, whether that is enough to establish physical force. And that would be the big question in this case, because the coercion's a little bit shaky, because they can't establish when exactly the threat to harm either her or him in the future, if she told anyone, whether that would be used to accomplish that.
Are you suggesting that threat of harm has to come before the penetration?
If it's to be accomplished, if the unlawful penetration is to be accomplished by coercion, that would have to occur before the act. After the act is done, I don't think it would be relevant in terms of being used to accomplish the penetration. We have provided, yes, Judge.
Rape wouldn't be considered a continuing offense?
Continuing.
Yeah, I mean, well, what if we went halfway through and decided, I don't want this anymore? Can't someone say stop and you have to stop?
Well, that would go to consent. That would go to consent.
And she can't give it anyway.
Then that's correct. We're not arguing that there's no lack of, there was no consent in this case. What we're arguing is that force or coercion, which was what Mr. Perry was given notice of in the indictment, was not sufficient to support it. And that's ultimately the question for this court, is whether there was enough, disregarding the fact that there was a variance from the indictment for lack of consent, such that it would render that variance harmless. If there are no further questions from the court, we'll just ask that this court, well, I'll save that for the minute. I'll turn it over to the state and rely on the remainder of my time for rebuttal. Thank you.
Good morning, Your Honors. May it please the court, Samantha Simpson on behalf of the state of Tennessee. Your Honors, this court should affirm the defendant's conviction for rape because any rational juror could have reasonably determined that the defendant raped the victim by force or coercion, and because the evidence presented at trial did not vary from the offense alleged in the indictment. To address the defendant's contention that the evidence was insufficient for rape, the defendant was charged with rape by force or coercion. And as defense counsel noted, the jury was instructed as to the elements of force and coercion. And force is defined as compulsion by the use of physical power or violence and shall be broadly construed to accomplish the purposes of Title 39, which defines criminal offenses. And here, there is sufficient evidence such that any rational juror could have reasonably concluded that the defendant forcibly raped the victim. As Judge Ogle noted, the victim testified that she unsuccessfully tried to push the defendant away. And based on that testimony, a juror could have reasonably inferred that the defendant was using his physical power as an adult man to force this 13-year-old victim to submit to the rape. Additionally, the victim testified that the defendant's unlawful sexual penetration hurt her. And after the rape, she wiped her vaginal area and found blood. So based on the fact that she unsuccessfully pushed the defendant away, that the rape was painful to her and caused her to bleed, any rational juror could have reasonably concluded that the defendant forcibly raped the victim. To address the coercion factor, coercion is defined as threat of force or violence to be performed immediately or in the future. So the definition of itself does not define when the threat needs to be made. And I think Judge Williams, I believe it was Judge Williams that noted, couldn't the threat have been, even if we presume that the threat was made after the rape, it's still in furtherance of accomplishing the rape to try and coerce her into not disclosing the offense. So here, any juror could have reasonably inferred that the defendant's threat to harm himself or the victim was made in furtherance of his goal to accomplish the rape. Additionally, Your Honors, the jury could have considered the evidence of non-consent as to be probative of the evidence of force or coercion. This court has noted in several opinions that force and consent or lack of consent are related concepts. In State versus Green, which this court decided in 2002, this court impliedly considered force and consent to be opposites, like two sides of the same coin. If a defendant forcibly rapes a victim, axiomatically, the victim did not consent. And in State versus Osborne, which this court decided in 2006, this court stated that a fair reading of the rape statute demonstrated that the statute required an element of overcoming the victim's will and necessarily involving a lack of consent. So here, the jury could have, when the jury heard the victim's testimony that, no, I did not agree to let him penetrate me, the jury could have reasonably heard that testimony and determined that it was probative of the evidence supporting the defendant's forcible rape. And as this court has consistently concluded, the uncorroborated testimony of a minor victim can be sufficient to sustain a conviction for forcible rape. So based on the victim's testimony, the evidence was sufficient to support the defendant's conviction of rape. And unless this court has any questions about the sufficiency issue, I'll move to the fatal variance issue. So initially, the state contends that the defendant has waived plenary review of this issue. And in the defendant's reply brief, the defendant contends that Issues such as fatal variances cannot be waived because relief would not be in the form of a motion for a new trial. But the state is not raising waiver under that specific ground. The state is arguing the defendant has waived review because the defendant has raised this issue for the first time on appeal. The defendant did not object during the victim's testimony about consent. The defendant did not object during closing argument when the state referenced consent, and the defendant did not raise this in the motion for new trial or the motion for new trial hearing. And in State versus Johnson, this court held that issues raised for the first time on appeal are waived. Additionally, I found two cases where this court has addressed a fatal variance issue under plain error. In State versus Folk, which was decided in 2009, and in State versus Weilacher, this court initially issued an opinion on direct appeal and concluded that many issues of the defendants were waived, and he later received post-conviction relief in the form of a delayed direct appeal. So procedurally, that case, Weilacher, is a little different from what we're dealing with here. But after this court issued its opinion on delayed direct appeal, the Tennessee Supreme Court remanded and ordered this court to consider the fatal variance issue under plain error review. So it is not true that that fatal variance issues can never be considered under plain error review. And plain error would be appropriate here because the defendant is raising it for the first time on appeal.
Could it be addressed solely on sufficiency? We always look at sufficiency.
Yes, Your Honor. While fatal variance and sufficiency are interrelated issues, obviously you look at the sufficiency and the evidence that was presented in terms of the fatal variance issue. But here again, it's because it was raised for the first time on appeal. But regardless of whether this court addresses the issue under plain error or plenary review, the result is the same. The evidence here, there was no fatal variance. The defendant was indicted for rape by force or coercion. And the state presented evidence of force or coercion, namely the victim's testimony that she unsuccessfully tried to push the defendant away, that the rape hurt, that she bled from the rape, and that the defendant threatened to harm her. So the jury could have only convicted the defendant of rape by force or coercion because the trial court instructed the jury on rape by force or coercion. And on appeal, this court must presume that the jury followed those instructions. So
in those instructions, did the trial judge mention anything about lack of consent can be considered as force or coercion? And did he follow the pattern jury instructions in giving the charge?
Your Honor, it's page 54 of, I believe it's the technical record volume. And the trial court defined rape as the following essential elements: so the defendant had unlawful sexual penetration of the alleged victim, and that force or coercion was used to accomplish the act, and that the defendant acted either intentionally, knowingly, or recklessly. And then the court went on to define coercion, force, and sexual penetration, as well as victim and the various levels of culpability. So to answer your first question, Judge Williams, no, the trial court did not instruct on consent. And Your Honor, would you refresh my memory of your second question?
It was, did he equate lack of consent? Did he instruct the jury that they could consider lack of consent as being evidence of force or coercion?
No, Your Honor, that was not in the instructions. The trial court only defined force, coercion, sexual penetration, victim, intentionally, knowingly, recklessly.
That's the
So
way the
here-
state argument that, didn't the state argue it that way in closing, that that, well, I've got it in front of me. Consent could mean, a lack of consent could be force or coercion.
Your
Something to
Honor,
that effect.
the state did bring up the victim's lack of consent during its closing argument, but our argument is not evidence. And again, here the jury could have considered that evidence of lack of consent as being probative of the forcible rape. So here, the evidence of lack of consent, the jury either disregarded it because the trial court instructed them on force or coercion, or they considered that evidence to be probative of that forcible rape. So here, again, whether this court considers this issue under plenary review or plain error review, there was no fatal variance. The defendant was indicted on forcible rape or rape by force or coercion, that the state presented evidence of rape by force or coercion. The trial court instructed the jury on force or coercion. And the jury verdict sheet states that the jury found the defendant guilty of rape. So there is simply no variance between the offense alleged and the offense that the defendant was convicted of.
Did the jury ask for, initially the jury was having trouble coming to a verdict. Were there
Yes, Your Honor.
were there any further instructions given to the jury after they advised the court that they didn't think they could reach a verdict?
Your Honor, my recollection of the record is that the jury left the deliberation room and the trial court individually polled some of the jurors to determine whether they believed they could come to a unanimous decision. And when some of the jurors said, yes, I believe we can, the trial court instructed the jury to return to deliberating to see if they could come to that unanimous decision. And then they did, resulting in the guilty verdict. I do not recall the exact language that the trial court used, but that was a summary of what happened.
Thank you.
General Simpson, that's not an issue that's been raised on appeal, is it? I mean, my review of the defendant's brief is that the only issue is this sufficiency of evidence on the question of consent. Is that correct? Or was the conversation with the court and the jury during deliberations, is that an issue that we need to be concerned about?
No, Your Honor. And the trial court properly instructed, did not try to sway the jury one way or the other. The trial court simply, when some of the jurors said, yes, I think we can come to that unanimous decision, the trial court said, okay, go back, keep deliberating. And that was it. And Judge Easter, you're right. The defendant has not raised any allegations of error about the trial court's interaction with the jurors on that ground. And unless this court has any further questions, the state respectfully requests that this court affirm the defendant's conviction for rape. Thank you.
Thank you. Counselor?
Thank you, Judge. Judge Easter in the court, my recollection of the trial court's interaction with the jury is exactly the same as the state's. And the judge instructed them to go back and deliberate. He did not tell them to go back and give me a verdict. There's nothing improper.
Ms. Jones, a note in your reply, you really don't address the state's citing of Green and Osborne, that we have this court and I guess our Supreme Court in Osborne perhaps has equated force and coercion with consent before. Are you aware of any case that says they are not the same?
No. And I mention that because the canons of statutory construction dictate that you can't read the statute in order to mean that one of the elements creates a redundancy. And if they do that, then it does. Now, the problem with that is force and coercion are defined, and they were defined for the jury. Consent was not. And there can be an argument that there's a common understanding of what consent is, and then the question for the jury would be whether the facts of the case, such as they were, dictated that consent was reasonably, that the defendant thought that there was enough to indicate that there was consent, or whether there was not enough to indicate consent.
And that's
Logic.
essentially, that's what Green and Osborne say, correct?
Correct, but that goes against, if you read force and coercion to be the same thing as lack of consent, it can't, one, perhaps there's an argument that it can be evidence of the other, but coercion specifically says that there's a threat or use of future harm in order to accomplish the act. And force is defined as physical force to be broadly construed. Neither of those go toward consent. So it could be that lack of consent is implicated by someone forcibly pushing themselves on someone, or that there was not a lack of consent because the coercion was used. But to argue that they mean the same thing, even if the case law said that, that flies in the face of statutory construction. And I understand the logical practicality of that and what the,
Has
and
the
what,
statute been changed since those cases?
no, the statute for rape has, to my knowledge, never changed. And to that end, that, Judge Easter, that gets to my first point, that to read one as evidence of the other, even though the case law says it reads a redundancy into the statute, that if lack of consent is indicative of use of force or coercion, then it renders one of the elements of the offense redundant. And I'm aware of the logical inconsistencies in that, but that's where it is. Two, counsel for state mentions that while there is no time placed upon when the threat or force, the coercive act or statement should be made, the jury instruction and the statute reads the unlawful sexual penetration of the alleged victim by the defendant was accomplished by the use of force or coercion. So the actus reus has to be accomplished by the use of that coercive. So I think the state's reading of that it can be used at any time afterward to have perhaps cover up, while that may be another offense, it's not necessarily evidence that a coercive threat was used to accomplish the unlawful penetration. I think that's an expansive reading of the statute and the jury instruction. And third, I agree with Judge Ogle. This is essentially, even though they did not address it, this is a case out of the 26th Judicial District, even though they did not request it during trial, at the motion for new trial, variance is essentially an issue of sufficiency, which is what I mentioned in my opening comments to this court, that the dispositive question for this court is essentially, if this was not harmless, if there was sufficient evidence for force or coercion, then it means that if they presented proof of lack of consent, which is much more, although argument is not evidence, testimony by the victim was evidence, and there was testimony about lack of consent. Even if that was present and the defendant did not agree to that constructive amendment, if there was proof that there's sufficient proof that there was force or coercion, then that renders that harmless. So the analysis is the same. And for that reason, it's not waived and this ready for this court's review. And to that end, if there are no further questions by this court, we would just ask that this court reverse and vacate this conviction for Mr. Perry. And I thank you for your time.
Thank both of you for very well presented arguments. We'll take this under advisement. We'll stand in recess until the call of the next case. Thank you.
This Honorable Court of Tennessee is now in recess.